Texas has a long tradition of promoting entrepreneurship and economic innovation. That tradition is carried forward in the way in which Texas law treats litigation finance. Rejecting outmoded analyses that are common in many states, Texas courts have concluded litigation finance agreements are lawful and that litigation finance should not be subject to usury law because they are investments and not loans. The leading Texas case on litigation finance is Anglo-Dutch Petroleum International Incorporated versus Haskell. Anglo-Dutch Petroleum had a valuable claim against Halliburton, but lacked the resources to pay for litigation. It tried to find commercial loans to cover litigation costs, offering an interest in the claim as security, but no bank was willing to make such a loan. Anglo-Dutch Petroleum then sought other investors, and Haskell agreed to invest $650,000 in return for a share of the recovery. Anglo-Dutch Petroleum won at trial, and while the appeals were pending, reached a settlement with Halliburton. But it challenged the legality of its investment agreement with Haskell, claiming it was void as against public policy and illegal under Texas usury statutes. The trial court ruled in Haskell's favor, holding that the investment agreement was enforceable. With respect to the public policy issues, the Texas Court of Appeals held that litigation finance agreements cannot be voided on the basis of the public policy. To reach this conclusion, the court first noted that Texas has long permitted the free assignment of claims and the proceeds of claims. Consequently, if a contract, like the one between Anglo-Dutch Petroleum and Haskell, provided for the assignment of the proceeds of a claim, it was lawful and in accord with public policy. In this connection, the court concluded that there was nothing about litigation finance agreements that made them likely to promote frivolous claims or to improperly extend litigation. They concluded by indicating that a litigation finance agreement could violate public policy only if it permitted the investor to control the litigation. The Haskell Court also held that a litigation finance agreement is not regulated by Texas usury laws, as long as the litigant has not obtained incontrovertible proof of its claim at the time of the execution of the agreement. Thus, in Texas, as in other states, if the litigant's duty to repay the investor is contingent, not absolute, the transaction cannot be characterized as a loan. In this connection, the court pointed out that even if the investor's fee was calculated as a percentage of the investment that increased over time, the transaction did not become a loan if the litigant did not have an absolute duty to repay. The analysis in Haskell is impressive. It recognizes the economic realities of litigation finance and how those realities impact the parties' motives and the course of litigation when one party has financing. The decision shows where the law on litigation finance is going. If you need help with litigation funding, call or email me today.